Welcome back to the Friday Five for February 24th, 2023. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today we're going to look at 5 questions from the last 2 weeks. I had to miss last week because I was out of the office with COVID. So we've got 2 weeks worth of questions, 5 quick questions that maybe you run into once in a while and you were curious what the answers were. Question number 1, should I use a professional service to be the personal representative or executor under my will? This is a pretty common question I get from clients who aren't really sure who should serve as the executor or the personal representative. They're not sure who they'd want to leave in charge of their estate, or as all commonly happens with married people, they know that they want their spouse to be the personal representative or the executor, but they don't have anybody else they're thinking of as the secondary person, as the backup person. So in this case, there are services out there that you can hire essentially to be the personal representative for your estate. Now, the reason I don't normally suggest this for my clients is this service is not free. So they will do the work for you. They will manage your estate for you, for your family after you're gone, but you're going to pay them a fee. And the more work that's involved, the more of your estate that's going to go to that professional service rather than go to the family members or the places you would like it to go to. So before you consider using that professional service, I'd say give it a little bit longer look. Think some more people in your life who may be a good fit to be the personal representative for your estate. It's not necessarily going to be a ton of work, and if they get overwhelmed, they can actually hire an attorney on behalf of the estate to help them go through the process. But a lot of times it doesn't make sense to use a professional service who's only going to eat up part of your estate that would have gone to your family members or other loved ones. Question number 2 this week, how can I choose a guardian for my young children? So this came up in the context of this client had a couple of adult children and some children born a little bit later who are under 18. Now, one of the children above the age of 18 is actually someone with special needs, and so this client was appointed as the legal guardian for his child who's over the age of 18. But we have other children under 18 who don't have any special needs, but we do want to make sure we're appointing a guardian for them under your will. So that if something happens to you and your spouse, or if you're a single parent and the other parent's out of the picture, you want to make sure that there's someone appointed as the guardian for your children if something happens to you while they are under the age of 18. This is different than a formal guardianship that you would appoint for somebody who's over the age of 18. That's a legal proceeding where somebody over 18 who's technically an adult has someone appointed. In this case, we're looking at people who are under 18. And you should note that if you have a child with special needs who's under the age of 18 and you're appointing someone as the guardian under the will, that person doesn't automatically become the guardian when they turn 18. There may be further legal proceedings. And this is where you want to make sure you're talking to a lawyer so that you have the right progression of people involved in their life to protect them when they hit that age of 18. Question number 3, do I need to choose an alternate person for my healthcare power of attorney? So kind of again, going back to question number 1, we're trying to find the right people for the right roles in our estate plan. And again, many people when they're married, when they're choosing that person for the healthcare power of attorney, the natural choice is going to be their spouse. Or let's say you're not married and you just have a sibling or just your parents are alive, it's easy to choose them. But then the question is, do you want to have a backup? Do you want to have an alternate? And my advice is always, if you can think of one that would be a good fit, then yes, you do. Because if you choose your spouse and you're both in a car accident, then nobody is there to make health decisions for both of you if you become incapacitated. And you don't have to have, if you're spouses, you don't have to have the same person as your backup. You can have your brother, your spouse can have their sister, you can have cousins, whoever you want it to be. But I always suggest for my clients that if possible, we do name a backup just in case something happens to their primary healthcare power of attorney. Question number 4. If somebody's breached a contract that I've entered into, do I need to bring a lawsuit immediately? Now, this becomes a very fact-specific case that we have to look at your actual contract and see. So in this case, the client that I was speaking with has a contract and there's been a breach by the other side. However, there's also a provision that requires them to try to work it out, to provide notices with each other, time to cure any default, and then there's also an arbitration clause so that before you can even file a lawsuit, the parties are supposed to go to arbitration to try to work out any disputes that they may have. So a lot of times people will come to my office and say, so-and-so's breached a contract, I need to file a lawsuit right away. But before you do that, you need to check the dispute resolution provisions in your contract so that you know what the right procedure is to do any disputes. You don't want it to be where you run to court and file, and then the other side just files a defense saying, hold on, we agreed to arbitrate, and then the court will just put your case on hold or may even dismiss it and make you go to arbitration first before you can come back and actually participate in your lawsuit. Question number 5 for the week. Do I need to hire a lawyer to bring the lawsuit if my company was technically the party to the contract? So in this case, same party as the last question, what had happened is the person was doing all the work, but they had set up an LLC to provide services to another company. So the contract is in the name of the company, not them individually, which is usually a good idea. If you've set up that LLC, we want to take full advantage of it. But in that case, the client wanted to know, can he file the lawsuit because he's the one who did all the work, he was the one involved, he signed the paperwork. But the reality is the LLC is the proper party. And when that LLC is the proper party, unless you're an attorney who runs a business, you probably need to have an attorney represent you to file the lawsuit. You can't just file on behalf of your company. This is a pretty common provision across the country, but you always want to check with your local rules. Sometimes your local rules may have an exception for small claims courts and some other types of cases specifically. However, generally, if your LLC is going to be party to a lawsuit, if your company is going to be the party to a lawsuit, you will need to hire an attorney to represent the company for that lawsuit. So that's our questions for the last couple of weeks. As I said, I was under the weather a bit with COVID, and then we got hit with a pretty big snowstorm here in Minnesota, but we're slowly digging out and getting ready for March to come. There's that hope for spring break and warm weather on the horizon. So there'll be a link in the description if you want to ask questions for a future episode. If you found this helpful, I'd love it if you hit the like button, and you can subscribe on YouTube or other channels so you can get it each week on Fridays. And I hope you have a wonderful weekend and that the weather is holding up wherever you are.